If there is one interruption by you, you will be held in contempt of court. What it is you want to say or not, because you're interrupting me. Okay, now I'm holding you in contempt. I've given you one chance right now. The court is going to indicate the state of Michigan versus Shadid Howard Randolph 2330.
This guy walked into court like he was part of a serious legal drama, but it quickly turned into something very different. He went straight into the "I don't recognize this court's authority" argument, apparently believing that would stop everything in its tracks. The judge gave him a short moment to speak, clearly hoping he'd settle down, but that patience didn't last long. What followed was a rapid shift in tone. Contempt charges started adding up, and it became obvious he didn't even realize he was creating bigger problems for himself. It raises a fair question. Should judges even engage with arguments like this, or shut them down immediately? Let's get into it.
For the people, please.
Good morning, Your Honor. Please, the people, P214.
Thank you. And Mr. Howard Randolph, your name, please.
Shadid Howard Randolph.
Okay, so before we go any further, I'm going to make this statement. I'm going to indicate the last time you were here in court, sir, which was April 20th, there was significant disruption to the court record. So I'm going to state this. If there is one interruption by you with anybody that's talking on the record, whether it be the prosecutor, your attorney, any witness testimony, or the court, you will be held in contempt of court. I just want to make sure you understand that. Do you understand that?
Can you repeat it again? Did I do something wrong? You said I did something wrong.
What I indicated is the last time you were here in court on April 20th, there was a lot of interruptions. You had a disastrous record. We had a disastrous record. So what I'm indicating, so I can make sure that we have a clear record and that I am maintaining order in the courtroom, that there will not be any interruptions by you, whether when the prosecutor is talking, your attorney is talking, any other witness, or myself. If there are any interruptions by you, Mr. Howard Randolph, this court is going to hold you in contempt of court. Do you understand that?
Yes.
And Your Honor, my client understands that I will be speaking for him today, pretty much for the majority of this, for this proceeding. So I don't believe that's going to be an issue. But thank you, and we're well noticed that everyone has to wait their turn to speak. Thank you for the notification. No, you cannot. You just were told no interruptions. Just stand there quietly. I will do all the talking. Just interrupted me, and that's something you said you weren't going to do. I'll do all this. We're ready to proceed, Your Honor.
Okay, Ms. Ozera, would you like to address the court? If you can step forward, please.
Yes, Your Honor. I am representing Ms. Duff in the custody matter, and with regard to Mr. Howard Randolph potentially being in custody, that was something that we did inform the judge of yesterday, and he said that he would accommodate as necessary if that is the case. I plan to appear as soon as I am back to my computer to inform the judge of the way that these proceedings conclude. I would also like the court to note that while it's been made clear to Mr. Howard Randolph that there is no contact electronically or by other means, that throughout the trial proceedings, Mr. Howard Randolph has continually directly addressed Ms. Duff during these proceedings, which would violate the no contact. And I believe that that will continue to happen. The decorum of Mr. Howard Randolph today might be great, but throughout the Zoom trial has not been great, and he has made threats and has spoken in threatening ways to myself as well as Ms. Duff.
And when you indicate that Mr. Randolph has been addressing Ms. Duff directly, is that during Mr. Randolph's turn to ask questions? Is he representing himself?
He is representing himself. It has not been with regard to any direct examination of Ms. Duff. He has not chosen to, at this point thus far, to question Ms. Duff personally or cross-examine her. This has been in his statements to the court, which then devolved into him directly addressing Ms. Duff.
And Your Honor, we're going to be in the process of getting the transcripts of that particular hearing this week. We don't know the specifics. If the court were not be inclined to reduce further, I would only ask for this one allowance that my client just financed a vehicle. It's in the parking lot. Is no one else to get the vehicle. He asked if I'd be willing to drive to his address. I indicated that it doesn't fall within the things that I'd be willing to do. I asked that my client get a report date later today, if not tomorrow, so he could just take the car back. Because not only is he going to be missing the hearing, he's going to be going into custody. I don't want him to be in a position where his car gets towed and he's going further and further down an avenue that we're just trying to halt and put back into an advantageous position. He understands that if he fails to appear, the consequences are going to be it's going to be a catastrophe. So that would be the only allowance if there'd be no bending on any further bond conditions, that he be able to report into custody after taking his car in.
Okay, and I can appreciate that, counsel, but Mr. Randolph can leave his key at the window with the police department, and we can make sure that they're not having it towed, and then his girlfriend can come pick up the key later with the vehicle. I'm not giving him a report date, not at all. I have serious concerns for safety and compliance with this court's order. So the court is indicating 10,000, 10%, no surety, GPS tether in the event bond is posted. You can leave your key with the police department, and then we'll make a note your vehicle is, so that it's not towed and that somebody can pick it up within the next 24 hours or so.
Can I say something for the courts?
That's up to your attorney.
Oh, no, it's up to me. I got my own mouth. Please, you don't already do what you're gonna do, bro.
This is where things start to unravel, quietly at first. There's no yelling yet, just a noticeable tension building in the room. The judge actually tries to help him by explaining how he can avoid having his car towed. It's a clear opportunity to de-escalate. But instead of taking that option, he just sits there, visibly irritated, as if he's preparing to argue further. You can feel that moment before everything tips over. Judges have limits, and when someone keeps pushing, the consequences shift quickly. Suddenly, it's no longer about the original issue, it's about conduct in the courtroom. Court isn't a platform for speeches or personal theories, and this defendant keeps treating it like one. Even the bailiff seems ready, knowing another interruption is coming. At this point, it's not a surprise anymore, it's inevitable.
Sir,
Okay.
let me just be very clear.
Mhm.
Your attorney would advise you whether or not you should or should not address the court based upon what it is you want to say or not. Because
commission needs.
you're interrupting me.
Okay, go ahead.
Because something you say could be used against you.
Mm-hmm.
So that is why I indicated if your attorney suggests that you speak.
I'm just saying the Michigan Tenure Commission needs to hear about this.
Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly intending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings.
Okay.
The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to indicate 15 days jail for contempt. The court's going to also indicate that while, sir, you were
15 days may sound severe at first, but context matters. The judge wasn't reacting emotionally, he was restoring control. When someone repeatedly disrupts proceedings, silence becomes necessary. Contempt isn't about punishment for disagreement, it's about preserving order. This defendant turned the courtroom into a stage instead of respecting the process. He may walk away believing he made a stand, but the reality is simple. His actions earned him time behind bars, not a legal victory.
Quiet and not interrupting this court's order, nor the proceedings. Towards the end of the proceedings, then you began to interrupt this court.
I ain't get loud, I just spoke my mind.
Despite this court's order not to.
Not to speak my mind?
Not to interrupt this court.
I didn't interrupt.
Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay. But hey, you filed a false police report, you let it get in your courtroom, so did the prosecutor and the team.
Sir,
commission will hear about it, and it's already, you got a grievance on you already right now.
Sir,
And
you may file anything that you
June the
choose.
1st, hey, listen,
You
this
may
domestic violence.
Stop interrupting.
You're gonna
Stop
get sued.
interrupting.
I guarantee that.
Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the
Rio, I'll tell
17th.
you, baby.
You're
Yeah.
not to
That's
address,
okay. I'm addressing the bar though. I'll
Sir,
bet you that.
sir, the court's adding your next 10 days on for you addressing the off the record.
That final statement didn't help him at all. Instead of showing awareness or restraint, it came across as defiant and reckless. If you're asking a judge for leniency, that's not the moment to escalate. Honestly, 25 days could have been worse under the circumstances. Judges aren't there to absorb frustration or manage personal protests. They are there to enforce the law and maintain order. What's concerning isn't just this one incident, it's how common these situations are becoming. So what do you think? Is this kind of behavior rooted in confusion, or do people truly believe they're accomplishing something by acting this way? Share your thoughts below, and if you're interested in more courtroom breakdowns like this, make sure to like and subscribe.